Hello, everybody. Once again, Craig DeLuz with the Firearms Policy Coalition here with you. I am at the Gun Rights Policy Conference 2022 in Dallas, Texas. Once again, this is a gathering where you get folks who are working on the ground in the Second Amendment community fighting for our right to keep and bear arms. And folks, there are a ton of people here that you are going to want to meet, but probably few that are more important to our fight than this individual who I have with me today. He is with the Independence Institute, and his name is Mr. David Kopel. David, welcome to the program.
No, thank you for having me.
Excellent, sir. Anybody who's watched any, whether it's congressional hearings or whatever it is, where people are talking about the right to keep and bear arms, understanding that right and how it's applied legally and statistically and all that, there are very few people who do a better job of communicating the importance and the history of the right to keep and bear arms than you do.
Well, thank you.
So tell us a little bit about your background, how you got into this area of expertise.
Sure. So I went to the University of Michigan Law School, and I was on the Law Review, which is in legal scholarship, students edit the subject journals. So I was on the Michigan Law Review, and the review was publishing an article by this guy named Don Cates called Handgun Prohibition and the Original Meaning of the Second Amendment, which turned out to be an absolute groundbreaking article among law professors and more broadly. And so students check the citations in legal scholarship because every factual sentence you have has to be backed up by a footnote showing where you got that information.
Right.
And so I learned about it from that, and then after law school, I was working as a corporate lawyer, but also interested in getting involved in public affairs and had a variety of different interests. But I reached out to this guy, Don Cates, who was very interested and real positive and wanted to get me on board and doing stuff. And so he invited me to present a paper at an academic seminar, and I'll say it was not one of the highest prestige academic seminars in that food chain. It was the meeting of the Popular Culture Association that was in Montreal, and so I flew up and presented a paper, which later which was the genesis of my first book, The Samurai, the Mountie, and the Cowboy: Should America Adopt the Gun Controls of Other Democracies? And the interesting thing was, that this was starting in the late 80s. Now the field of gun control and gun rights has a lot of people on both sides working in it. It was a much more thinly populated thing at the time. So as a guy who was just out of law school and wanted to make a contribution in public affairs, it was a good choice because I was fairly quickly one of the top experts in the country because there weren't very many of them. And I like the First Amendment just as much as the Second. But if I focused mainly on the First Amendment, well, there were 400 law professors in line ahead of me who knew way more than I did at the time. So this was it turned out to be an efficient place to go.
I'm curious, do you think it was because maybe until before that time in American history, it was kind of obvious what, the right to keep and bear arms shall not be infringed? It was kind of obvious what it meant?
It was obvious for a lot of American history. Although, of course, there's always room for argument about whether a particular gun control does or does not infringe the right. But there was a great forgetting in some quarters. I think the American public, at least according to the opinion polls, always recognized the Second Amendment right the way it was recognized in 1822 or 1922 or today, that it's a right of individuals to own and carry arms, and especially firearms, for lawful purposes. But in elite opinion, this idea that got started with a Kansas Supreme Court opinion from 1905 had, by the 1960s, really spread among the legal academy, lawyers, the highly educated. That whatever they couldn't really describe what the Second Amendment meant, but they were sure that it was not an individual right. And some would say it's a collective right only, it's a state's right only, or some kind of thing like that. But the bottom line was it had no meaningful legal effect. Mm-hmm. And so that was a pretty predominant attitude in the federal courts, the lower federal courts. starting in the late 1960s and continuing into the 70s and 80s. So a lot of what I did and other scholars like Steve Hallbrook or Don Cates, David Hardy, and others was to reacquaint the elite opinion and the public in general with the historical interpretation of the Second Amendment at the beginning, the preceding rights in colonial times, and then from then onward in American history.
Well, and the reason I think why the elite get away with kind of getting with changing definitions is because the people forget. And so I think it's important to make sure that we remind people. Like it was amazing to me how many lower courts and then eventually legislatures seemed to almost ignore Heller and McDonald really until New York Rifle and Pistol came along.
That's true, and they didn't ignore it in the sense that they pretended it doesn't exist, but they, I think, willfully or aggressively misread those cases. And I talked about this at Constitution Day at the Cato Institute when they released their annual book reviewing the Supreme Court's past term. A lot of the lower courts didn't follow the example of Heller and McDonald, which is you look to understand the right, you look at first of all the text, and then how that text has been understood in American history to further illuminate any questions you might have about the meaning of the text. And they instead really adopted Justice Breyer's dissent from Heller, in which he says, all right, let's just assume it is an individual right for purposes of argument. Courts should just engage in freestanding interest balancing to decide whether an infringement of the right is beneficial enough compared to how severely the right is infringed. And so he argued that under his analysis, a handgun ban in Washington, D.C. was okay. And a lot of the courts, not all of them, but too many of them, went in that direction, not upholding handgun bans per se, because that Heller was clear enough on that, but upholding all kinds of other gun controls, for which the government could provide some empirical evidence in support, even if it was contested, and that would be enough for gun controls to be upheld in a lot of places. And it was really the Supreme Court's fault that this happened, because people kept filing petitions for certiorari. I wrote amicus briefs on some of those and telling the court, hey, your honors, this case is representative of a problem that is widespread in the lower federal courts of judges just blowing off Heller basically and doing deciding cases the way you expressly said in Heller not to do it, which is we reject the Breyer interest balancing test. Breyer was Breyer was writing the dissent, but as a former lawyer for Handgun Control Incorporated, which for a long time was the leading gun ban group in the country, Alan Rostron later became a professor at the University of Missouri Kansas City Law School, and he wrote I think an accurate article titled Justice Breyer's Triumph in the Third Battle of the Second Amendment. It's like, well, he lost in Heller, right. He lost in McDonald, but hey, in the lower courts, he seems like he's doing pretty well and he's winning, and that was right. And the Supreme Court didn't do anything about it, so some courts got bolder and bolder.
It's almost seemed to be like the only part of Heller they saw was it's not an unlimited right, and you can have reasonable regulation. And they redefined the term reasonable to be whatever we want.
Yeah, and that was certainly true. It was a particularly serious problem in the Second Circuit, which covers New York and Connecticut and that area, and the Fourth Circuit, the Ninth Circuit, among others. Mm-hmm. So for example, in the Ninth Circuit, you would sometimes get decisions by a 3-judge panel that would uphold the Second Amendment and say this particular gun control goes way too far. But then the Ninth Circuit as a whole would then take the case en banc, where you hear it before a panel of In the Ninth Circuit, I think it's 15 judges.
I think it's 11.
11. Okay.
Yeah.
11. So. And they'd go before this 11-judge, get an 11-judge panel, and the 11-judge panel would always reverse any favorable decision from a 3-judge panel. And, en bancs are a real logistical challenge for a court to arrange, so they don't do them often. But they would en banc Second Amendment cases, even when the losing party in the panel hadn't asked for an en banc.
Yep.
They would just take it spontaneously.
So now that we're post New York Rifle and Pistol, or post-Bruin, we're starting to see municipalities now do things like, specifically, at least what I'm seeing is they're addressing the whole sensitive places issue, and clearly ignoring what I think was written into the opinion, as well as they really seem to be going after now and expanding the good character aspect of some of their laws.
Well, that's certainly true in New York State, where Governor Hochul, like her predecessor, Governor Andrew Cuomo, used a special legislative procedure to evade the normal New York State Constitution rule that a bill has to be available for people to read for 3 days before you pass it, so that the legislators and the public can find out what's in it. And sometimes they'll find out parts that were misdrafted or had unintended consequences. But she got it rammed through in a matter of hours. And as she was asked, well, under this new thing, people are going to get carry licenses. Where are they going to be able to carry? And she said, maybe some streets. And that was it, because they'd basically define everything else as a sensitive place where carry's prohibited. So, and it's not just carrying that they ban, it's the possession of a firearm at all. So, for example, if you have a home that's inside a state park, you can't have a gun in your home. If you're a minister, they ban guns in churches, and you're a minister who wants to and has been lawfully carrying a firearm, say in upstate New York, where some of the counties were good about giving out permits fairly. You can't do that, and you live in the rectory, and you can't have a gun in your own bedroom in the rectory. So and lots of other things, doctors' offices, on and on and on. It's a extreme, flagrant defiance of the Supreme Court, really anti-constitution. So for all those people who say that our democracy is under pressure and in danger, I agree with that, but it's not just a problem that comes from one side of the political spectrum. She is no different, in my mind, from the segregationist Southern governors who, after the Supreme Court in Brown versus Board of Education, said you cannot force a child who lives 3 blocks from this school and is black and wants to go to her neighborhood school, you can't force her to go to some inferior school 5 miles away that's for black students only. And the court was very clear on that, but a lot of anti-constitution politicians defied that and got away with it for a number of years, and so she's very much in that mold.
If you were to look forward over the next 5 to 10 years or so, what would you say kind of are the going to be the important areas of firearm policy that either are going to be they're going to be important either in the courts or in various legislatures?
Well, certainly there's continuing fights over gun bans,
right,
and bans on common rifles, and likewise bans on standard size magazines. That'll continue to go on. I think it's I've been involved in this issue since for I suppose with Don Cates since 1983, working on his article. But the anti-gun movement, like the pro-gun movement, is much larger than it used to be. And with Bloomberg now, you've got one of the richest men in the world who hires great public relations geniuses and pays for a huge staff. And so they're always cooking stuff up. And I think they proved that they're fairly adaptable to circumstances. Obviously, Bloomberg himself was part of an amicus brief in the Heller case saying, no, there's no Second Amendment right in any meaningful sense at all for an individual to have a firearm for self-defense. And he lost that, but then they was able to pivot fairly quickly to saying, oh, my organization definitely supports the Second Amendment, but we just want reasonable gun controls on that. So and I think one of the things they've been working on really successfully in a long-term strategic sense is gun registration. And less so in the clumsier way that it was attempted and failed, say, in Montana in 1919 and quickly repealed by the legislature, of saying, oh, everybody, you got to come in to the police station, give us a list of your guns. But they're capturing 4473 forms from gun dealers and digitizing them into a national database. I think a big part of their attempt to so-called universal background checks to force even, loaning a gun to your friend, so your friend can go on can go hunting for a week or take the gun to a target range for safety training. Even those things have to be routed through a FFL. And so if you do that, then the FFL has to fill out a 4473, and so you get more of those lists, and that's another why they're so hostile to this ridiculous marketing term of ghost guns, of people doing what's always been lawful and proper in the United States, of manufacturing your own firearm for yourself at home. If you want to go into business and start selling them, then you got to play by the federal rules of the Gun Control Act and put serial numbers on them and fill out all the paperwork and get an FFL. But if it's just for yourself, you don't have to do that, and they're trying to end that. So the objective I think they really want is the largest list possible of the most gun owners and the most guns. And then this is the credit card reporting things. Supposedly this is going to stop a mass shooting because some criminals have bought guns with a credit card. Well, so have hundreds of millions or at least tens of millions of law-abiding, decent citizens. But you make any transaction at a gun store into a separate merchant category. Well, then now you've created another database of people who at least buy things at gun stores, which is a good hint they might be a gun owner. And so then they're not going to be able to do confiscation, next year. But I think in their view, which is from their point of view strategic and thoughtful, when the time comes when it might be politically viable, you got to start with the list. You can't send every police officer door to door looking around for the guns. You have to have a list first, and that's why in Australia, which is their model that they talk about all the time, and the United Kingdom, they did registration, comprehensive gun registration, before they did the confiscation.
Wow. I could go on in this conversation. How can folks follow you and the work that you're doing with the Independence Institute?
Well, go to my website, which is davekopel.org, davekopel.org, and you can read my briefs and law journal articles and other things, all there for free. I blog for the Volokh Conspiracy, Volokh, which is currently hosted by Reason Magazine. That's the most influential law professor weblog since the dawn of time, at least on this planet.
I agree.
Yeah. And I'm on Twitter at Dave Kopel, Davekopel. So I guess start with that, and I'd say if you really want to have some fun, buy some of my books. Two recent ones. One's fairly recent. One's The Morality of Self-Defense and Military Action, the Judeo-Christian Perspective, which looks at the whole issue of when is the use of force, either personally or collectively, like as a nation, permissible or not, under different understandings of Judeo-Christian scripture and ethical interpretations. And then my co-authored law school textbook, Firearms Law and the Second Amendment, has recently had its third edition out, and the website for that is firearmsregulation.com, I believe. But there's also a link for my site. It's a law school textbook, but it's meant to be accessible to an intelligent layman as well. Now it costs $299, which is a lot of money, but it's 1,400 pages, so on a cost per word basis, it's a real bargain. And some of the chapters, beyond those 1,400 pages, we've got 7 more supplemental chapters that are online only and available for free.
Wow, excellent. So thank you so much for taking the time to join us. I know our viewers have really enjoyed having the opportunity to hear from you.
Well, thanks, and I love working with your organization. You guys do great work.
Excellent. Thank you so much. Ladies and gentlemen, Professor David Kopel.
Thanks.
All right, folks. Well, hey, we still got more interviews coming up, so you guys stay tuned. As soon as you guys get those alerts, click on in and start watching. We will be back with more interviews from Gun Rights Policy Conference 2022. See you again real soon.
All right, thanks.
If you like our videos, follow, subscribe, like, and share.